for pretrial conference in the cases, and we are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with.
Thank you, Your Honor. Doug Hartung appearing for the people today.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Mark Silvertooth. We both appear via Zoom. Thank you for allowing that. We consent to such. Mark, please state your name for the court.
Mark Anthony Silvertooth.
Okay, we did have a brief discussion off the record. I believe we've agreed to an adjournment to January 22nd at 8:15. Is that correct, Mr. Amadeo?
That is correct, Your Honor. And if I could put the terms of the potential offer so he hears it, if that's acceptable.
Go ahead.
Okay, Mark, I'm going to come see you, but here's what we discussed. To clear up all the files, there'd be a 1-year jail sentence, which you're getting good time credit for. You'd be out shortly. That would clean up all your files. I would also stipulate to the competency. You did come back competent. I will come to see you probably this weekend. This is the deal we talked about earlier with no prison involved. Judge did meet us in the breakout room. I said he would be agreeable to that. Do you understand everything I just said?
Yeah.
Okay. Does that sound good?
Yes.
Okay. I will come see you this weekend and review everything, and we should get this done on the 22nd. Do you understand?
Yes, sir.
Okay. Thank you. Thank you, Judge.
Thank you.
Okay, and did you want to resolve the competency issue today, or did you want to wait until next week?
Judge, we will stipulate to the competency report today. Fine.
Okay.
He has been deemed competent.
All right, so the court has received a report from the Department of Health and Human Services Center for Forensic Psychiatry, dated December 30, 2024, and that is authored by Jessica Pawlinski, MD, which has resulted in a finding that Mr. Silvertooth is competent to stand trial. Mr. Hartung, are you in agreement or willing to stipulate to entry of that report as evidence to make the determination?
Yes, Your Honor.
So based on that report, then the court will find that Mr. Silvertooth is competent to stand trial. And we will again adjourn this matter to 2 weeks from today, January 22nd at 8:15.
Thank you, Judge.
Okay, thank you for your time today, Mr. Silvertooth. You can let the officer that's with you know that you're done with court for today.
All right. Thank you.
Thank you, Your Honor.
Thank you, Bill.
Take care, Mark. I'll see you soon.
Okay. Well,
Okay, Mr. Murphy, I have Ms. Kitley here in the courtroom in person. Do you need to speak to her?
Your Honor, this morning is a show cause. I'm not sure what the show cause is about. Is this an arraignment on that? Because I'd ask if we could proceed with that first.
Sure. Ms. Kitley, can you come forward to the podium, please? We are on the record now in file 24-22053-FH and 24-21883-FH. We are here today for arraignment on an order to show cause that alleges a violation of bond conditions. You are Taylor Lee Kitley?
Correct.
Have you received a copy of the motion in order to show cause?
I haven't.
Have you received a copy of it, Mr. Murphy?
I have not, Your Honor.
Okay, Mr. Murphy, I just sent that to you in an email.
Thank you.
Okay, so Ms. Kitley, bailiff has given you a copy of the motion affidavit in order to show cause. That document alleges that you violated the bond conditions by testing positive for THC, ETG, or alcohol and methamphetamine in a drug screen collected on December 11, 2020. The maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in. Do have the right to be represented by an attorney with regard to this alleged contempt and any hearings that we have on this matter, including today. If you can't afford an attorney, you can tell me that. I'll appoint one for you at public expense. Do you understand that?
Yes.
Do you want to have an attorney represent you?
Yeah.
And you do already have the public defender's office representing you on the underlying charge, so I'll appoint the public defender's office to represent you on this as well. Mr. Murphy, do you want an opportunity to speak to her? Or do you just want her to plead guilty? We can set, or not guilty, I apologize. And we can set this for the next date that we have a pretrial.
Your Honor, can we just do that? And then Ms. Kitley, I'll call you later today and talk about this, but I believe it's the 22nd is the next pretrial for the underlying. And unless you're going to be taken in custody on bond, I'll just ask for that to occur today.
Okay, and Mr. Coast, it does look like she has been testing negative since this test. Is that accurate?
That's true, Judge. The positive was sent to the lab and it was confirmed positive for the meth, but her last 5 tests have been negative. So she is back on track. She's doing better.
Okay. All right, so given that, I would give a PR bond on that.
Thank you, Your Honor.
So just set this for the date of your next pretrial, Ms. Kitley, is January 22nd, so 2 weeks from today. We'll just deal with everything at the same time.
Okay.
Okay, so you are all set for today then.
All right. Thank you.
Thank you, Your Honor.
They've got it. He's here. Yeah. Okay. Do you need to? You ready to go? Sure. Just a minute. Okay, good morning, Mr. Lyons. So you have Mr. Fenton and
Not a problem.
anyone else or just Mr. Fenton?
No, for that case, yeah, but I'm here on Shears. But the Shears,
Oh, Shears, yeah, I'm sorry.
he's just been set for an exam for the 23rd of this month. So I'll be asking to move his pretrial beyond that. I'm sure,
Okay.
post-exam.
Do you want-
Good morning, Ms. Wise.
Good morning.
Do you want to do anything with Mr. Shears on the record or?
No.
Okay.
I'll go see him in person this week.
And after the 23rd, so I could do January 29th would be the following Wednesday.
Here's the problem, Your Honor, and you guys can answer this better than I can. If he's bound over, how long would it take the file to get from district court up to your desk?
It's on the 23rd. That would that be here the next week? We don't have an answer with certainty on that. It could be here the 29th, but it may also wait until the 5th.
It would be on the 5th. They always do, if it's after like the Wednesday of the week, then it goes out a week and a half. So it would be the 5th.
So that would be the 5th then. Thank you, Ms. McCourt.
Mm-hmm.
I would respectfully ask to move it to the 5th, Your Honor.
Okay, so we can adjourn that one to February 5th. And Mr. Lyons, would you do a stipulation in order for that adjournment?
Not a problem, Your Honor. Ms. Wise, may I sign your name?
You can. I need to speak with you on Fenton though, because I think we have a pretrial on it.
Okay, not a problem. Is the young lady there who's doing the appeal?
No, but we got the order back. Did you get the order?
I did not.
Okay. Judge, did you get the order?
I did. If you give me a moment, I think I can forward that to you, Mr. Lyons.
Thank you. I'm gonna to the court and Miss Wise, Happy New Year.
You too.
Thank you.
So
And
far,
yeah, I just sent that, I forwarded the email that I got to you.
and I've got it right here, Your Honor.
And so I'm sorry, Ms. Wise, do you want a breakout session with Mr. Lyons?
Yes, please. Or if he wants to just call it, it's up to him. We can do a breakout.
Sounds good to me.
Thank you.
Hold off for a moment. I'm not sure if they're gonna. All right, so Mr. Fry, ready to proceed with Mr. Gillespie? All right, I have a device logged in that is labeled MJC Gillespie. If there's someone there, could you please unmute that device and start the video? Okay, so I still need to unmute that device.
Judge, Attorney Freeman called and said that she's in the waiting room.
Okay, this is file 24-22083-FH, People of the State of Michigan versus Jeremy Richard Gillespie. We are here today for an arraignment in this case, and we are proceeding today by video conference. First, I have the attorneys place their appearance on the record, beginning with Ms. McClure.
E.B. McClure on behalf of the people.
Brian Fry on behalf of Jeremy Gillespie.
All right, and Mr. Fry, does Mr. Gillespie wish to have the information read today?
No, Your Honor, we would waive the reading and ask the court to enter a not guilty plea.
All right, enter a not guilty plea for Mr. Gillespie and set this for a pretrial conference on February 5th. Work for you, Mr. Fry?
Yes, Your Honor.
February 5th at 8:15 a.m. Is there anything else we need to address today?
No, Your Honor, thank you.
No,
All right,
thank you.
Mr. Gillespie, you can let the officers with you know that you are done with court for today.
Okay.
Thank you, Your Honor.
Thank you, Mr. Fry. Okay, Mr. Lyons, are we going to do anything on the record today with Mr. Fenton?
Your Honor, we're going to ask that the matter be put over for a final pretrial, and I was going to suggest, with the court's permission, the 5th of February.
Yes, that would be fine. And can you do that stipulation in order also?
And I do have your permission, Sister Counsel.
Oh, I apologize, Ms. Freeman. We did receive the order from the Court of Appeals. I guess maybe we would need your input regarding whether there would be a further appeal planned or what that status is.
Yeah, I was going to suggest, I had spoken to Mr. Fenton and he has expressed that he does want to continue on to the Supreme Court. I don't know whether this court would entertain a stay in order for us to do that or not. But either way, we could ask for it in the Supreme Court if this court isn't inclined to do so.
Ms. Wise, I don't know if you're comfortable responding to that off the cuff, or do you want to address that issue?
Can we address
At a
that on
later time.
February 5th?
Yeah, I don't know. Ms. Freeman might not want to wait that long. I guess what I would say is that if you'd like to request a stay and have the court consider it, could you file a motion and then schedule that for a hearing? We can get that on our docket pretty quick, and that way everybody's got notice and an opportunity to be heard.
Yes, I can file a motion and get that a hearing date for that.
Okay.
Thank you.
So what I'll do, just so we have a date, is adjourn the pretrial to February 5th. And then Ms. Freeman and or Mr. Lyons, if you want to file that motion requesting a stay, we'll get that on the docket as quickly as we can.
Not a problem. And just for the record, counsel would have no objection to that stay, Your Honor.
All right. Anything else we need to address with Mr. Fenton's case today?
I'm
No,
satisfied.
thank you.
Nothing further.
Okay. Thank you very much. Okay, Mr. DeMattis, are you ready to proceed with it's Mr. Samuelson, right?
Yes, Your Honor.
Okay. All right, this is file 23-21614-FH, People versus Timothy Samuelson. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure?
E.B. McClure, map the people.
Thank you, Your Honor. Anthony D. Mattis on behalf of the defendant Timothy Samuelson. Tim, please state your name for the record.
Timothy Samuelson.
All right, and Mr. DeMattis, where do we stand with Mr. Samuelson's case today?
Yes, Your Honor. So we are very close to a resolution. Part of the deviation request that I was submitting to Ms. McClure's office contained the component of a mental health evaluation. With the holidays, we were just able to get that completed. So I'm either one asking for a short adjournment so I can get the deviation request and mental health evaluation over to Ms. McClure, or if the court finds it necessary to place us on the trial track, we'd ask for a final pretrial. As I said, Ms. McClure and I both anticipate this case being resolved short of trial.
Okay, Ms. McClure, anything to add from the people's side?
I would have no objection to getting one more pretrial in the case. I know it's an older case and this is the second attorney we've had on it, but I think I agree that we should be able to get it resolved once I review what Mr. DeMattis has gathered.
All right, if we go to January 29th, is that a sufficient amount of time?
Yes, I believe so. Yes. Phoebe, you need about a week to review everything you think would be good?
Yes.
Okay, perfect.
All right, so I'll adjourn to January 29th. I would be setting a trial date at that time, just based on the age of the case. I need to move it forward in one direction or another. So I appreciate that the attorneys believe there's a resolution close at hand. But we do need to move forward one way or the other at the next pretrial. And so I'd be setting it for trial on the 29th.
Thank you, Your Honor.
Okay, anything else we need to address for Mr. Samuelson's case today?
Nothing further on my end, Your Honor.
Okay, I think we're all set then. Mr. Samuelson, thank you. You can go ahead and log out.
Thank you, Your Honor. Thank you, Ms. McClure. You and your staff have a great week. Thank you.
Ms. Underwood, Mr. McCollum Rosa is here in the courtroom. Are you going to need to speak to him?
Yes, please, Your Honor.
Okay. Mr. McCollum Rosa, can you step outside? There's an iPad right outside the door. And I will put you in a breakout session with Ms. Underwood. You need to unmute that device. Mr. Castleberry, is Mr. Burke here?
He is, Your Honor.
Okay. You can go for it, Mr. Burke. This is file 24-22059-FH, People versus Douglas Stephen Burke. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, on behalf of the people.
Burke Castleberry on behalf of the defendant.
All right, and Mr. Castleberry, where do we stand with Mr. Burke's case today?
Your Honor, we are set for a Cobb's evaluation on January 16th at 10 a.m. This is our first pretrial. I am asking for a short adjournment to accomplish the Cobb's evaluation. I believe we will be entering a plea after that.
Okay. Ms. McClure, anything to add from the people's side?
No, no objection.
Okay. Does January 29th at 8:15 work?
So yes, Your Honor, that works.
Okay, so set for January 29th at 8:15 a.m. Mr. Casper, would you do the stipulation for?
I will.
Okay. Anything else we need to address?
That is it.
All right, thank you.
Thank you.
Thank you. Okay, Mr. Dagger Margosian, I have Mr. Reese here in the courtroom. Are you going to need to speak to him?
I don't think so, Your Honor. I spoke with him yesterday, but I do want a little bit of information from the court regarding what the show cause is for, if that's okay.
Okay, give me one moment. Okay, I believe it is for having the scram unit turned off. Let me just check the.
It wasn't turned off.
Okay, Mr. Reese, I can't have you just speak out like that.
Okay, sorry.
So, Mr. Coates, the only show cause I have is the one that was on September 4th. Is that correct, or is there a newer one?
Is this for Mark Reese, Judge?
Yes.
No, we have a couple of tamper alerts on a scram device, which occurred in mid-December.
Okay, let me find the order, Mr. Dagman goes in, and I'll send that to you.
Okay, thank you.
Okay, then, so Mr. Dagan-Margosian, did you want to talk with Mr. Reese before we have a hearing, or? No.
Well, I guess maybe what I would suggest if the court is open to entertain this is that Mr. Reese has sentencing coming up fairly shortly, on the 23rd. So in a few weeks, I'm wondering if it would make sense to push this out to that date and we can address it then. If we need to have a hearing, we can do that. Or if the court would, I guess if Mr. Reese, doesn't have any issues on bond, he's been fairly compliant with bond. He's come to every court date. So if the court would entertain that, if there are no issues up until sentencing, maybe setting this show cause aside, I'm just sort of spitballing here.
I'm willing to set that out for the date of sentencing. I've got to arraign him on it and get a plea entered, but I'm comfortable, I think, with adjourning it to the sentencing date, and we'll see what happens between now and then.
And Judge, I have not received any violations since that December 14th date, so that's a positive.
Okay. Mr. Reese, do you want to come forward to the podium, please? So this is file 24-21887-FH, People versus Mark Anthony Reese. We are here today for a hearing on an order to show cause regarding alleged bond violations. And we're proceeding today partially in person and partially by video conference. Sir, you are Mark Anthony Reese?
Yeah.
Mr. Reese, did you receive a copy of the motion affidavit in order to show cause?
To show cause?
Order to show cause, I can have the bailiff give it.
Oh, yeah, I got something in the mail. Yeah, I think I got that.
Okay.
That's why I knew to be here. Yeah,
Okay, yeah. So that order, with motion affidavit alleges that you violated your bond conditions by having obstruction events with respect to your scram device.
Yeah.
I don't want you to say anything about them right now, okay? I've got to let you know what your rights are, and then you can decide what you want to say, if anything. The maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines. You have the right to be represented by an attorney with respect to these allegations and any hearings that we have on these allegations, including the hearing that we're having here today. And if you can't afford an attorney, I'll appoint one for you from the public defender's office. Do you already have Mr. Dagan-Margosian representing you on the underlying files? Would you like to have him represent you on this as well?
Yeah.
Okay. I'll appoint him to represent you on the contempt allegation. We did just have a brief discussion. Mr. Dagan-Margosian, you'd like to have him plead not guilty. Is that correct?
For the time being, Your Honor, thank you.
All right. So I will enter a not guilty plea on the contempt violation or allegation. We do have sentencing coming up on January 23rd. And so I will set this for that same January 23rd date, and we will deal with everything at the same time. Okay. So I'll give PR bond on the order to show cause, and so Mr. Reese, you just need to be here on January 23rd for the sentencing hearing. Right. You're all set.
Yeah, thank you.
Thank you, Your Honor.
Thank you, Mr. Dagan-Margosian. Okay, Ms. Underwood, are you ready to proceed with Mr. McCollum Rosa?
Yes, Your Honor.
You can come forward to the podium, please. At the podium, please. This is file 24-21958-FH and 24-22070-FH. People versus Skylar Austin McCollum Rosa. We are here today for pretrial hearings in each of those cases, and we are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
V. McClure, on behalf of the people.
Rhonda, do it for Mr. McCollum Rosa, Your Honor.
All right, and where do we stand, Ms. Underwood, with Mr. McCollum
Your
Rosa's
Honor,
case?
there is a plea offer. We are close, I think, to a resolution, Your Honor, but we need one more pretrial.
Okay, Ms. McClure, anything to address from the people's side?
No, no objection, Judge.
I did have one question myself.
Mr. McCollum Rosa indicated he has a question. Ms. Underwood,
I just wanted to be able to appear on Zoom.
yes, that is fine, unless you're otherwise directed, you can appear on Zoom. Okay, how about January 29th?
That's fine, Your Honor. And I will be happy to do the stip to adjourn with Ms. McClure's permission.
Okay.
No objection.
All right, so January 29th at 8:15. And
Thank you,
Mr.
Your Honor.
McCollum Rosa, you can attend that by Zoom. The bailiff has other information if you need that.
Okay, I got confused today because I didn't know that you had to like accept me, because that's what I was supposed to do today. And then I just showed up in person because I just got nervous, like something was gonna happen. But so that's what happens is like you have to accept me, like it'll take a minute for anything to happen.
So yeah, when you log into the Zoom session, you'll see one of two things. If I haven't started the Zoom session, you'll see a message that says something like the host hasn't started the meeting yet. If I have started the meeting, you'll see a screen that says you're in the waiting room and just hold on, and then I bring people in kind of one at a time because it's difficult to manage if I have 30 or 40 people in the Zoom session at one time. So
yeah.
So if you find yourself in the waiting room, just stay where you are, and eventually I'll get to you.
Okay, I just wanted to understand that. Thank you.
Okay. All right, so you're all set for today.
All right, thank you, Your Honor.
Could we Timothy Kier and Burke judge, please? Thank you. Bye.
Versus Mr. Dagger Margosian, we do have Ms. Gerbers in the courtroom. Oh, I'm sorry. Do you need to speak with Mr. Gerbers?
Yes, please, Your Honor.
If you'll step outside to the iPad just outside the door, Mr. Gerbers, I will put you in a breakout session with your turn. Okay, Ms. Underwood, we have Timothy Kier coming to us at the jail in a minute.
I'm sorry, Your Honor.
This is Timothy Kier at the.
There's Mr. Kier.
Do you need to speak to him? Do you need a breakout session?
Just briefly, Your Honor.
Want to click join?
Yes. Great, this is file 20-20077-FH 21-20551-FH 21-20552-FH People versus Timothy Allen Kier. We're here today for hearing on probation violations or alleged probation violations in these cases, and we are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda, I'll do it for Mr. Kier, Your Honor.
Okay, and where do we stand on Mr. Kier's cases today?
Mr. Kier has a exam scheduled on one of the matters that is the subject of one of the violations on February 11th, Your Honor. We would ask for a adjournment of these matters till after that. However, as to the issue of bond, I believe the court gave Mr. Kier a PR bond pending with tether, Your Honor. Mr. Kier downstairs was given a PR bond with drug testing, Your Honor. Mr. Kier would be out, but he can't afford the tether, Your Honor. He's going to be on strict drug testing downstairs. I would assume his probation officer up here would require strict drug testing and his reporting, Your Honor. I would ask if the tether provision could be stricken at this time, Your Honor, if Mr. Kier violates by testing dirty or if he fails to report, Mr. Kier knows he'll end up back right where he is. But I believe he has no money for the tether, and this would allow him to get out and to work, Your Honor. And providing he remains law-abiding and drug-free, I think that's the goal for everyone with Mr. Kier.
Miss
All right, you said
Hollywood,
his, I'm sorry, you said his exam is on the 11th of February?
Yes.
February
Ms.
11th, Judge.
I can do February 12th, Ms. Underwood, for a next pretrial.
That's fine.
Miss Holly would request the same conditions as before regarding him being released, Judge.
Related to all my reports.
All right, having reviewed the files and the underlying charges in Mr. Kier's cases, I think at this point I am willing to rely on drug testing provisions that are happening in the district court. I would include parallel drug testing provisions for Mr. Kier on these cases. But I will at this point remove the GPS tether restriction.
Thank you, Your Honor.
Thank you, Your Honor.
So, Mr. Kier, your next date is February 12th at 8:15 a.m. Should he report as soon as he's released, Ms. Walsh?
He should give Miss Holly a call.
So contact your probation officer as soon as you're released.
Is she not at the courthouse? Can I just go straight to the courthouse?
Just give her a call.
Okay. It's different.
So you are all set for today, Mr. Kier. You can let the officer with you know that you're done with court.
All right, thank you.
Mr. Dagger Margosian, are you ready to proceed with Mr. Gerbers?
Yes, Your Honor.
Mr. Gerbers, you can come forward to the podium, please. This is file 24-22092-FH People versus Tracy Michael Gerbers. We are here today for an arraignment in this case, and we are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure?
B. McClure, on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. Gerbers.
Does Mr. Gerbers wish to have the information read this morning?
No, Your Honor.
And do you know how Mr. Gerbers wants to proceed today?
Your Honor, I'd ask for a pretrial set for this case. I'd like to review things a little further before we decide what to do with this case. So if we can just get a pretrial, that'd be great.
Okay, how about February 5th at 8:15?
That works.
Okay, so Mr. Gerbers, your next date will be February 5th at 8:15 a.m. Okay, you're all set.
Thank you, sir.
Thank you.
Sorry, I didn't enter a not guilty plea for Mr. Gerbers, so I will enter a not guilty plea for Mr. Gerbers. So you're all set now. Sorry about that.
Thank you.
Did you have anyone else today, Mr. Dagger Margosian?
Not in this court, I don't believe.
Okay. Okay, is Ms. Rule here? And you are Christine, correct? Okay, you can come forward and sit at the table closer to your jury box. This is file 24-51568-FH Christine Rule versus Karen Rule. We are here today for a hearing on an order to show cause regarding alleged violation of a personal protection order. We are proceeding today in person. The court also has the Zoom session running. And Miss, you are Christine Rule, correct?
Correct.
Karen Rule is not present today either by being here in person or by video conference. In reviewing the file, Ms. Rule, I don't see a proof of service indicating that the order to show cause was served on Karen Rule. Was that accomplished?
I assumed it was. They have never called me anytime they've ever served her. But I have the receipt where I paid them to do it.
All right, I don't have a proof of service either in the physical file or that I can see in the computer system. Let me pass this for a moment and I'll send someone over to the clerk's office to see if it's been filed but just hasn't made it to the file yet. So you can go ahead and take a seat back where you were.
Okay.
Come back to you in a minute. Office and or ask maybe ask Francis for the clerk's office and ask for it. Okay. Okay, Mr. Murphy, I have Kayla Johnson here. Do you need to speak to her?
If I could, please, Your Honor.
They don't have a judge.
No, Kelly, the judge will say first. Could we have? Thank you.
Okay, Ms. Rule, do you want to come back forward, please? Okay, we are back on the record in file 24-51568-PH. Christine Rule versus Karen Rule. We have at this point checked with the clerk's office, and they also do not have a proof of service indicating that it's been served on, that the order has been served on Karen Rule. So I can't, under those circumstances, go forward today. What I can do is reschedule this, and the court will send out a notice of hearing by mail, but you will need to contact your process server and make sure that a copy of the order actually gets served on her, so that she knows what the allegations are. And here today, and actually, if you want to wait, I'll have that notice of hearing. We'll get that prepared. You can take a copy of that with you and have the process server deliver that new notice of hearing along with the personal, or with the order to show cause. And so we'll set that for January 22nd at 8:15. And assuming we can get service at that point, we'll go forward at that time. Okay, so if you want to just stay here for a minute, we'll get you a copy of the new notice of hearing. Okay, Mr. Murphy, are you ready to proceed with Ms. Johnson?
Yes, Your Honor.
Okay, this is file 24-22054-FH, People versus Kayla Johnson. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure?
B.B. McClure, behalf of the people.
Matthew Murphy, appearing on behalf of Ms. Johnson.
All right, and Mr. Murphy, where do we stand with Ms. Johnson's case today?
Your Honor, there's a plea offer made by Ms. McClure in this matter for Ms. Johnson to plead to count 2, possession of cocaine, dismiss any habitual, which I don't know if there's habitual offender status on there or not, but dismiss count 1, which is possession of methamphetamine, with an agreement for no upfront jail. Ms. Johnson does wish to accept that plea offer and again plead to count 2, possession of cocaine. We did sign that plea agreement. We sent it over to the court. I don't know how long it'll take for it to get there, but we are willing to do that today.
Okay, Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is.
All right. Ms. Johnson, will you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Kayla Nicole Johnson?
Yes.
Ms. Johnson, you heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, possession of cocaine less than 25 grams?
Yes.
Are you satisfied with Mr. Murphy and the advice he's given you?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $25,000 fine?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That's correct.
Mr. Murphy?
That's correct, Your Honor.
Is that also your understanding, Ms. Johnson?
Can you say that one more time? Somebody coughed.
Neither the prosecutor, defendant, or anyone acting on your behalf has discussed a possible sentence with the court.
Oh. Yes, I thought they said something about no jail time and probation, but
Yeah, the plea agreement involved no upfront jail. Other than that, there's been no discussions with the court.
Okay, other than that agreement, Ms. Johnson, would you agree that other than as we've discussed it on the record today, no one has had any conversations with me about a possible sentence?
yeah, yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Johnson, that if your plea is accepted, you'll be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about June 5, 2024, in the city of Adrian, county of Lenawee, that you did commit the offense of possession of cocaine less than 25 grams?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Johnson to plead guilty today?
No, Your Honor.
No, Your Honor, I just told Ms. Johnson that after the pleas entered, I was going to ask the court to address her bond conditions.
All right, Ms. Johnson, has your attorney promised you any particular sentence or estimated what your sentence would be, other than as we've discussed it on the record this morning?
No, he said something about probation. It could be from probably like 1 to 4 years or something like that.
Right, and you understand that that decision would be made by me after I've had a chance to review your pre-sentence investigation and hear what you have to say about the issue.
Yeah.
Is it your own choice to plead guilty today?
Yeah.
Mr. Murphy, do you want to cover the factual basis?
Yes, Your Honor, thank you. Ms. Johnson, were you indeed in the city of Adrian, county of Lenawee, state of Michigan on June 5th of 2024?
Yes.
And at that date and time, did you have in your possession a substance that was cocaine?
Yes.
Did you know that it was cocaine when you had it in your possession?
Yes.
And would you agree that the amount of that cocaine was less than 25 grams?
Yes.
Now, did you believe that you had any prescription or any legal right to possess that cocaine?
I don't understand the question.
Did a doctor or anyone tell you that you should take that cocaine for any type of medical purpose?
No.
Your Honor, I believe I've established the factual basis for the charge.
Satisfied, Judge.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Murphy?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Johnson has had full knowledge of her rights and she has had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as it's been addressed on the record here today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for February 13th at 8:15 a.m. Ms. Johnson, you're going to be required to do a pre-sentence investigation interview with the probation department. When you do that interview, please be truthful about this offense and about your background. And I'm going to put you in a breakout session with Ms. Walsh from the probation department so she can collect your contact information.
Your Honor, could we address bond before that occurs or after that occurs?
I apologize. Yeah, I apologize. Go ahead.
Your Honor, Ms. Johnson was asking if the court be willing to consider reducing her regimen of testing, possibly down to regular and random or something less. She is obviously attending and making the drug test. I don't believe I've gotten any report from Mr. Coe saying that she's failed any tests. This event did occur quite a few months ago, back in June. Since then, I don't believe. Again, she was had another case. She hasn't had any violations on that in regards to testing. It's just a matter of again, the testing being a bit burdensome in regards to the financial wise and trying to work it around her work schedule now. But if the court was to continue it, she would obviously abide by it, but she is asking the court to consider reducing the drug testing regimen.
Ms. McClure, any input from the people?
I would leave it in the discretion of the court, but just add that she was screened for drug court, and I believe she was not high risk enough, is what they said. So I think it would be appropriate to modify conditions at this time, as long as there's still something in place.
Okay. Looks like these bond conditions have been in place since about the middle of September, and there's nothing in the file to indicate that there's been any violations or use. So at this point, I would be comfortable reducing that to regular and random testing as opposed to what the requirements are. So I will make that.
Thank you, Your Honor.
Thank you.
All right, so Ms. Johnson, now I'm going to put you in a breakout session with Ms. Walsh from the probation department, and she will collect your contact information. If you give me just about 10 seconds here. All right, and then Mr. Murphy, did you need to speak to Mr. Madison?
If I could, please, Your Honor. Thank you.
Okay, Rhonda, I have you left only with Chad Till, is that right?
Is Mr. Till there in person, Your Honor?
No, I thought he was MDOC. Sorry. I guess I just assumed that because it was presumed. Yeah. Looks like that wasn't me. Sergio, can you check and see, do we have anyone from MDOC here today? No, sir, we don't have anybody. We do have a writ for Mr. Till, and there's an email in the file from MDOC acknowledging it, but Mr. Till is not here today, so.
That's the same thing that happened with, I had someone earlier this week. That's crazy.
Ms. Johnson, you're all set. You can leave the meeting if you like.
Okay, I'm trying to figure out how, but I can't find it. This is like my first time using Zoom. So
That's fine. I can do it from my side for you.
Okay, thank you.
Did MDOC?
Okay, so
MDOC did not transport Mr. Till?
there's no one here.
Yeah, they confirmed it. I mean, just on our end, just so everyone's aware, but yeah, this is the second one they've done in a week.
So I don't know what to do other than just set another date and we will try it again. How about January 29th?
That's fine with me, Your Honor. Do you want me to do a stip to adjourn with Ms. McClure's permission? Or will the court send out notices?
I would greatly appreciate it if you could do a stip in order and then Ms. McClure, the prosecutor's office, could do another writ.
Yes, we can do that.
Thank you. And then, Ms. Underwood, the only other one I had for you was Carpenter versus Novak.
Right.
It was a.
Did he appear, Your Honor?
No, Mr. Carpenter is not here. I'm sorry, Mr. Novak is not here. Yeah. So this is the one he had a charge in district court that resulted from the alleged violation of the PPO. But my understanding was that that was dismissed at the request of the petitioner.
Oh, I think this was supposed to be dismissed too. I don't. Yeah.
And he didn't appear the last time, and we set it over for today to try to figure out what was happening with it. So
I wouldn't bench warrant this, Your Honor. I think what you were going to do last time was just take it off the docket.
Why don't you go on the record? So this is file 24-51863-PP. Ashley Carpenter versus Montana Novak. We are here today for a hearing on an alleged personal protection order violation. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Novak this morning, Your Honor. Thank you.
All right, the record should reflect that neither Ms. Carpenter nor Mr. Novak have appeared here today. This is the second time that has happened. The court had a hearing on this a couple of weeks ago or a few weeks ago, and neither party appeared. I am also aware that according to the Register of Actions in the district court, that the criminal charge related to this alleged violation was dismissed at the request of Ms. Carpenter. Based on that and the fact that she's not appeared at any of the hearings on this since that has happened, I am going to dismiss the alleged violation in this case.
Thank you, Your Honor. I believe that concludes my docket with you this morning.
Okay, yes, I think we're all set. Thank you. And Mr. Murphy, are you ready to proceed with Mr. Madison? Mr. Murphy, are you there? All right, Mr. Murphy, I think has stepped away from his device. We will proceed, Mr. Madison, with your case as soon as he's back.
Yes, sir.
Yeah, and I'm sorry. I just stepped away from my desk real quick.
Okay. All right, so this is file 23-21242-FH, 24-21996-FH, and 24-21997-FH. People of the State of Michigan versus Brandon Lorenz Joe Madison. We are here today for a probation violation in the 23 case and pretrials in the 24 cases. First, let me have the attorneys place their appearance on the record. Ms. McClure, are you there? She may have stepped away from her desk as well. Oh, there she is.
Nope, I'm here. I just thought it was a probation. I apologize.
Okay.
Matthew Murphy,
yeah.
Mr. Madison. I'm sorry.
Go ahead. Yeah, and Mr. Murphy, where do we stand with Mr. Madison's cases today?
Your Honor, Mr. Madison wanted to ask the court to continue a not guilty plea on the underlying charges, the resisting opposing officer charge and the prisoner contraband charge, and set those for another pretrial in the matter. I think further negotiations might be fruitful in the matter before setting a trial on that. And then in regards to the contempt of court and probation violation, Mr. Madison wanted to accept responsibility and plead guilty to those today.
I'm filling in for Mr. Stevenson, Mr. Murphy, and I don't have the violations in front of me. Are the violations for the new charges?
Thought it was for not appearing.
Yeah, failure to appear, probation violation hearing, and
okay,
we find the actual violation.
And then we have the contempt for not drug testing.
So the violation was a failure to report.
Okay.
Yeah, I have July 2nd and July 9th. There's another one after that.
Okay.
I'm sorry, Mr. Coates, you said there was a failure to test?
That's correct, Judge. He failed a test. He's supposed to be testing one time a week. Failed a test on 10/22 and also 10/29. And he has not tested at all with me.
So is there a probation violation summons on the failure to test? I only have one for the failure to report.
Judge, there was a summons. It should be the file. I do have a copy if you don't have a copy.
It's not a probation violation, it'd be a violation of his bond conditions. So.
Correct. It's a contempt of court for the bond violation.
What's the date on the failure to test?
The
date that the order was filed.
It was actually signed on 10/30 of 24.
Oh, okay. All right, Mr. Madison, would you raise your right hand, please? You swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, yes, sir.
And you are Brandon Lorenz Joe Madison, correct?
Yes, sir.
Okay, I'm going to start with the violation of probation first. Do you understand that you have a right to contest the violation of probation charge in the 23 file and to have a trial on that?
Yes, sir.
You understand that throughout that trial, you would be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes, sir.
You would have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand all of that?
Yes, sir.
You are not required to testify at your trial, and no one can hold that against you in any way. Do you understand that?
Yes, sir.
Do you also understand that you have the right to testify at your trial if you wanted to testify?
Yes, sir.
And how do you want to plead to the charge in the 23 case that you violated your probation by failing to report on November 12th and 19th of 2024?
Guilty, sir.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've explained to you?
Yes, sir.
Has anything been promised to you in order to get you to plead guilty?
No, sir.
Have you been threatened in any way in order to get you to plead guilty?
No, sir.
If I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Yes, sir.
So you were placed on probation and had an order of probation in the 2023 case, is that correct?
Yes, sir.
And that order of probation required you to report to your probation officer as often as you were instructed to report. Is that also correct?
Yes, sir.
And were you instructed to report on November 12th and November 19th of 2024?
Yes, sir.
And did you fail to report on those days?
Yes, sir.
Okay, I will accept that plea has been given understandably, voluntarily, and accurately. And with respect to the contempt allegations, Mr. Madison, do you understand that you have a right to a trial on those as well?
Yes, sir.
Do you understand the maximum possible penalty for the contempt is up to 93 days in jail or up to $7,500 in fines?
Yes, sir.
Do you understand that throughout the trial, with respect to the contempt allegations, you would be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, sir.
Again, you would have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. You have the right to have me order any witnesses you have for your defense to appear at that trial. Do you understand that?
Yes, sir.
Again, you're not required to testify at trial. No one can say anything about you not testifying or hold that against you in any way. Do you understand that as well?
Yes, sir.
And again, you'd also have the right to testify at the trial if you wanted to testify. Do you understand that?
Yes, sir.
And how do you want to plead to the charge that you violated your bond conditions by failing to appear in court on November 27, 2024?
Guilty, sir.
Okay, and how do you want to plead to the charge that you violated your bond conditions by failing to drug test on October 22nd and October 29th of 2024?
Guilty, sir.
Understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained.
Yes, sir.
Has anything been promised to you in order to get you to plead guilty?
No, sir.
Has anybody threatened you in any way in order to get you to plead guilty?
No, sir.
If I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Yes, sir.
So you acknowledge that you had bond conditions that required you to do drug testing. Is that correct?
Yes, sir.
And as a result of those bond conditions, you were required to drug test on October 22nd and October 29th of 2024. Is that also correct?
Yes, sir.
And you did not, in fact, test on those days. Is that correct?
No, sir.
No, that you didn't test, or no, that was not correct?
No, I did not test, sir.
Okay. I will accept those pleas then. They have been given understandably, voluntarily, and accurately. Mr. Madison has had full knowledge of his rights. He's had competent counsel. With respect to the probation violation, we would need to set a sentencing date for that so that his pre-sentence investigation report can be updated. I could do that on
Your Honor, could we make that the same time as a pretrial, whatever date that would be, if the prosecution's okay with that? I know typically sentencings are Thursdays and Fridays, so I don't know if that would work, but.
How far out do you want to look for your next pretrial?
Well, I'll be fine with, again, if we take 6 weeks for a sentencing date on the violation of probation, I'll be fine with setting the pretrial at, the date you set for the sentencing is what I was asking. Unless Ms. McClure had a different thought.
So 6 weeks would take us to February 19th.
That'll be fine for the defense, Your Honor.
Okay, Ms. McClure, any issues with that?
No, no issues.
Okay. So we'll set the pretrial and the sentencing on the contempts and the probation violation all for February 19th at 8:15.
Thank you, Your Honor.
Okay, Mr. Madison, you can let the officer with you know that you are done with court for today.
Okay.
Your Honor, Mr. Madison was asking the court in regards to the contempt of court. I don't know if you're willing to sentence him today on those or not. I don't know if that really would ultimately matter with the pending sentencing on the violation of probation, but he was just trying to clear up stuff as much as possible today. So I don't know if the court's willing to do that today on those.
Okay, is there anything you want to say on behalf of Mr. Madison with respect to the contempts before sentencing?
Your Honor, in regards to the contempts, Mr. Madison had communicated with Mr. Coast, and Mr. Coast had relayed back to him. Mr. Madison did have COVID, but he hasn't been able to provide documentation as such to Mr. Coast or to myself. I couldn't find that. But Mr. Madison, he is a recovering heroin addict. That is obviously the red spawn that contraband charge. Mr. Madison he does have a job that is going to start back up again, I believe, in late February at the golf course in Sylvania. Mr. Madison, he has been doing well in regards to abstaining from drug use. Obviously, the drug tests hadn't been completed to show that. But obviously, moving forward, Mr. Madison, he was just asking the court to consider in regards to the contempts, because again, they're not for appearing, to give him either credit for time served on those, or maybe a 30-day sentence on those, with credit for time served. He does apologize to the court for missing the court date. He does apologize for not being able to provide that documentation of his sickness, but he just wants to take responsibility and complete those, move forward in his life with those.
All right, Mr. Madison, anything you'd like to say before court passes sentence?
Yes, sir. I just want to say I apologize. Like I'm doing much better in my life in like I haven't been using drugs. I know it shows that I missed those drug tests, but at that point in time, I had caught COVID. And the paperwork was at my mom's house somewhere and I couldn't find it. I was trying to find it. And then I found the paperwork one day and I think I sent it to the wrong number, which Mr. Coast gave me. But like I drug test every month for the MAT program. I am on the MAT program. I drug test for them so I can get my Suboxones every month. And basically, I just apologize. I just want to plead guilty and get this stuff out the way. And if there's any way I can get back out to my life, because I mean, I was doing so much better in my life than I've ever done. And, thanks to the courts, because, the probation has helped me. It's helped me change and everything. And I just say, I'm sorry that we had to go through this again. If there's any way that I could be released on tether also, you know what I mean? Because I have so much that I've been doing and trying to be ahead. Like I didn't try to miss these court dates or miss my basically drops because I was trying to hide. That wasn't what I was trying to do. It's because I've been dealing with basically COVID, and then through COVID I got sick, and then I found out that I have some type of other problem, which was a lump on my brain that they don't know is cancerous yet. So basically it came from health problems. It wasn't because I was trying to avoid the courts. Like I was still in the city of Adrian when all this happened. Like if I was going to try to run, I would have took off and went somewhere else. But I just want to say, I apologize. I just want to plead guilty and just get this over with.
All right. It will be the sentence of the court then that Mr. Madison served 30 days at the Illinois County Jail with credit for 14 days served on the contempts.
Thank you, Your Honor.
All right, anything else to address today?
Mr. Murphy, can we address tether when my time's up?
Your Honor, I think Mr. Madison was asking the court to consider his bond on his violation of probation to allow him to be released on a tether. So I think that's what he was asking for.
Your Honor, if I may speak. Yeah, because I just paid $1,000 cash, a little more than that, to get out on the R&O case, and I had a PR bond on the contraband case. Like the contraband case, I had already paid my bond, and then the contraband case came up, and I walked right in there, and knowing I had that warrant, knowing that I could go to jail, I walked in there. Like, I'm not trying to evade any of these courts, but if so, just place me on tether so then you guys know where I'm at all times. I have no problem with that. But I will show up to every court date. No matter the outcome, no matter what anything happens, I will show up. And when I do get free, I have documentation that I will find to bring into the courts to show the courts that I had COVID and that I did go to these other doctor things. And I will test regularly, sir. No problem.
Ms. McClure, is there anything you want to say regarding the bond issue?
Judge, I'm sure you have a little bit more information than I do on the failure to appear, but my notes do reflect that even prior to the contempts that he just pled on, that he had a history of failure to appear. So unfortunately for Mr. Madison, I don't believe he's demonstrated that he will comply with court's orders and that he will appear regularly, that we can.
I'm in court, Charity.
So that we can get the case resolved. And so at this time, I would ask that he not be granted a lesser bond.
But Your Honor, I have walked into these courts every time.
I understand. I heard you. I heard you when you said it.
Yes, sir. I apologize.
All right. With respect to the new files, I will say that I'm willing to give Mr. Madison the opportunity to have a GPS tether in place. I don't believe that we have done that with Mr. Madison previously, and I think given the relative seriousness of the offenses alleged here, that a GPS tether would be appropriate. So I am going to reinstate the bonds on the 24 cases with the additional requirement that there be a GPS tether, and I would modify the bond on the violation of probation, the 23 case, to be a PR bond with a GPS tether.
Thank you, sir.
All right, so I think we've addressed everything there is to address today. Mr. Madison, you can let the officer that's with you know you're done with court.
Okay, thank you.
Thank you, Your Honor. Your Honor, I'm sorry, I have to log off. I have another hearing that was at 10 o'clock. Mr. Millar is going to cover the cases I have left. Thank you.
Okay. You wanna call Mr. And Mr. Malaro, Mr. Madrid is here in the courtroom. Are you going to need to speak to him?
Oh, yeah, Judge, if it's acceptable to the court, I would like to do the couple people I have that's in custody in jail on Zoom, and then I would come over because I do need to speak to Mr. Madrid. And it's going to be a plea, I think. So
Okay, we just called for Mr. Goble.
and I don't know who's in jail, but Goble and maybe Dillenbach. That's the one for Matt. I don't know if he's in jail or not.
He is not.
Okay.
He looks
so
like.
I could. Sorry, Court, Your Honor, but yeah, if I can do Mr. Goble and then I'll come over in person because I got a bunch of them.
Okay, I do have Mr. Getz is here on Zoom. You want to take care of him?
Oh yeah, that too.
You need to speak to Mr. Getz.
I don't think so, Judge. I think what I put on the record should be sufficient, and if he wants to speak with me, he can call me later.
This is file 24-22003-FH, People versus Joseph Douglas Getz. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Vanetto?
Morning, Your Honor. Alex Bayanetto for the people.
Salvatore Malero on behalf of Joseph Getz. Whoa.
All right, and where do we stand with Mr. Getz's case today?
Your Honor, I received a plea offer in writing that I'd like to review with Mr. Getz. And I have not had the opportunity to do so, so I'd ask for a brief adjournment for me to do that.
Mr. Vanetto, is there anything we need to address from the people's side?
No, Your Honor.
Mr. Malero, I can do January 29th.
That'd be fine, Judge.
And would you do that stipulation in order, please?
Yes.
Okay, so January 29th at 8:15 a.m. would be your next date, Mr. Getz. I would say that at that point, the case would be over 100 days since it was bound over to the circuit court, and I'd most likely be looking at setting it for trial if the matter is not resolved at that time.
Okay, thank you, Your Honor.
Okay, so Mr. Getz, you can go ahead and log out.
All right, thank you.
All right, I have a device that I just brought into the meeting. I believe it is a jail device. I need someone to unmute that device and start the video. jail and nothing with the device they just logged in yesterday.
So the judge says that the room that they're using right now, the device needs to be turned on. Okay. Oh, so he's not, yeah, they will make sure it's up and running. All right, thank you. Bye.
Your Honor, can you hear us?
Yes, thank you.
You're welcome.
Mr. Malero, do you need to speak to Mr. Goble?
Real briefly, Judge.
Okay, 1 second.
Thank you, Your Honor.
Nope, don't touch that.
Okay, Mr. Malero, Mr. Goble does not appear to be in the Zoom. Oh, there he is.
Yes, I can't tell if you want me to leave or not.
No, you stay,
No,
Mr. Goble.
Yeah, Mr. Goble, you need to just stay for a few more minutes. We need to go on the record for your case, okay? All right, this is file 24-21915-FH and 24-21916-FH, People versus Michael Ronald Goble. We are here today for a pretrial conference in both of those cases, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.V. McClure, may I have the people?
Salvatore Malero on behalf of Pastor Michael Goble.
All right, and Mr. Malero, where do we stand with Mr. Goble's case today?
I'm going to request an adjournment of this matter for a few reasons. The first reason is that Mr. Goble has recently been charged with another offense that is set out, I think, to January 23rd. And then the other reason is that due to the purported victim in that case, a conflict has arisen, and this is going to have to be referred out. And whoever the new attorney is going to be is going to need some time to get up to speed. So that would be the basis for our adjournment request.
What is the date of the district court hearing?
The district court hearing, Your Honor, has been adjourned to January 23rd for another probable cause conference.
All right, well, I guess, Ms. McClure, is there anything that the people wish to be heard on this morning?
Just that because that case is only set for probable cause and we're unsure yet if it's going to be waived or set for an exam, could we get maybe a pretrial at the end of February to make sure there's enough time for that case to hopefully catch up without any further delays?
Obviously, the fact that the public defender's office has to disqualify would be good cause for an adjournment. That's going to require some time for a new attorney to get into the case. So there is good cause for the adjournment. I will adjourn this to February 19th at 8:15 a.m.
And if either the public defender's office or the court learns of who the new attorney is, will you please just shoot me an email so I know to reach out?
Yeah, I'll have Sarah tell Burke to let you know who it is.
Okay, thank you.
All right. In light of the fact that Mr. Malero needs to disqualify or have conflict, the court will review this and send that out. Anything else that we need to address today?
I would only say, Judge, since our office I believe has a conflict, that I not prepare the stipend order that the prosecutor's office do so.
The court will just adjourn and send out the notice. I think that's probably the better way to go.
Okay, thank you, Judge. I appreciate it.
All right, Mr. Goble, you can let the officer with you know that you are done with court.
I'm sorry, I didn't hear that.
You're all set.
Oh, okay.
Okay, and then Mr.
Thank you,
Valero,
Judge.
you're coming
I'm on my
over
way
in
over.
person. Okay.
Yep, I'm on my way over.
Judge, do you still have Ryan Hoover set for 11 o'clock today, or did that get adjourned?
I still have that for 11 o'clock.
Okay, all right. Miss Arnold left me a note that she thought the motion part was already taken care of, so she didn't know if there would still be a pretrial today. So I'm gonna log out and I'll log back in at 11 for that.
Okay,
Thanks.
thank you. What's that? Yeah. Okay, so Mr. Madrid and Mr. Sadler, Mr. Malero is coming over to the courthouse, so he'll show up here in a few minutes and we'll get started as soon as he's here.